Okay, hello class, and in lieu of our class for tonight, I'm going to make a short discussion, on the intellectual property code. Now, when we talk about the intellectual property code, this is, of course, in relation to Section 13, Article 14 of the Constitution. And here, it was mandated, the state was mandated to protect and secure the exclusive rights of the scientists, inventors, artists, and other gifted citizens to their intellectual property and creations, particularly when beneficial to the people for such period as may be provided by law. And of course, it is in recognition of the intellectual and industrial property system, which is vital to the development of the domestic and creative activity, facilitates transfer of technology, and attracts foreign investments and ensures market access for our products. And again, like any other municipal law that we have or local law that we have, we are a signatory to a lot of conventions on the protection of intellectual property, and that's why we need to come up with the intellectual property code. It institutionalizes these mandates in the Constitution. Now, what do we mean when we say intellectual property rights? So these are a set of rights, and it covers the following. First, we have copyright, trademarks and service marks, geographic indications, industrial designs, patents, layout designs or topographies of integrated circuits, protection of undisclosed information. So, medyo madami siya. But, for purposes of the bar exam, of course, focus really would be on copyright, trademarks, as well as patents. Okay? Now, let's talk about the patent law. Now, when we say patent law, okay, what is the purpose? First, it seeks to foster and reward invention para naman ma-encourage, di ba, yung ating mga creatives in order for them to make more inventions. Okay? Second, it promotes disclosure of inventions in order to stimulate further innovation. And third, the requirements for patent protection seeks to ensure that the ideas in the public domain remain there for the use of the public. And this was in Perlendin Incorporated versus Schumart Incorporated. So it has a threefold purpose. Now, who has the right to a patent? First, it belongs to the inventor, his heirs, or assigns. And let's say dalawa kayo, diba? You were working on an idea and you invented something, then the right to that patent belongs to you jointly. Okay. Can you transfer your rights under your patent? Yes. Okay. As long as the assignment is made in writing and it is notarized. Now, patentable. What inventions are patentable? It must be new. It must involve an inventive step, and there must be industrial application. Okay. So, however, under the IP or Intellectual Property Code, it may be or may relate to a product or process or an improvement of any of such. Okay. So, pwede rin naman, and that is good because again, some ideas are no longer new. However, if you can improve on it, if you can improve on that process, then yes, it is still patentable. But take note, there are lots of things which are not patentable. What are these? So, discoveries, scientific theories, mathematical methods, okay? So, these are not patentable. Nandiyan na sila. Hindi mo na siya pwedeng i-patent na, uy, parang meron akong bagong formula in order to get the sum of sine and cosine, etc. No, you cannot patent it. Now, schemes, rules, and methods of performing mental acts, playing games, or doing business, and programs for computers. So, you cannot patent it. Methods for treatment of the human or animal body by surgery or therapy and diagnostic methods practiced on the human or animal body. plant varieties or animal breeds are essentially biological process for the production of plants or animals. No, you cannot patent that. Aesthetic creations and anything which is contrary to public order or morality. So you cannot patent this. And I think the reason for this is simply because if people will be allowed to patent it and to earn from it, then development will be stunted. No? Kasi ikaw na lang. And kailangan bayaran yung cure. Kailangan bayaran yung let's say method of surgery. So that is not good for human development. Okay. Now, how long is a patent? No? How long would you be able to hold on to a patent? So it shall be 20 years from the filing date of the application. Now, what about the so-called first to file rule? Now, we always hear of sino mauna, sino ang magkakaroon ng patent, because again, sometimes we cannot control the human mind, and on one hand, A is thinking about it and trying to upgrade a particular scheme, and then ganun din naman pala yung isa. So who will now hold the patent? Now, if two or more persons have made the invention separately and independently of each other, the right to the patent shall belong to the person who filed the application for such invention, or where two or more applications are filed for the same invention, to the applicant who has the earliest filing date or the earliest priority date. Kaya ito nangyayari, unahan. Okay? Kasi nga, posible that they have similar inventions. Okay. Now, what else do we need to remember about patent law? Okay, now infringement. Now, let's say you already have a patent. Now, what happens if someone else, okay, uses it while your patent is subsisting? So, the making, the using, the offering for sale, selling or importing a patented product or a product obtained directly or indirectly from a patented process, or the use of a patented process without the authorization of the patentee constitutes patent infringement. That is the offense. So in intellectual property class, whenever you violate any of these rights, of the rights of the holder, that is automatically an infringement, and therefore lahat ng offense na yan infringement. Here we're talking about patent infringement. Okay, so if you do that without the authorization of the patent holder, then you are automatically guilty, or liable for infringement. Okay. Kaya dapat mag-iingat kasi hindi pwede basta gamitin, lalo na if it is patented. Okay. Now, what about trademarks? Okay. So, when we say trademarks, it also includes service marks and trade names. And what are these? So, trademark, this is a visible sign. Okay? Capable of distinguishing the goods. So, for instance, yung paborito nyong sapatos, Nike, diba? Yung swoosh ng Nike, that is the trademark. Okay? Yung tatlong lines ng Adidas. Or, given as an example, by one of the reporters, that Apple, which makes it an Apple product. Okay, so these are the trademarks. Now, what about services or service mark? Okay, so ito yung mga stamped or marked container of the goods. Now, trade name, of course, is the name or designation identifying or distinguishing an enterprise. Okay, so when we say trade name class, it includes what? The business as well as its goodwill. Okay, kasi kilala mo na yun, yung pangalan niya, Jollibee. Diba? Yun yung trade name niya. When we say Jollibee, we know what it means. Now, what about the trademark? The trademark refers to the goods. Okay. Now, why do we allow the registration of these trademarks, and why do we have these trademarks? So, we have these trademarks now to indicate the origin or ownership of the articles to which they are attached. And that's why, again, when you see the swoosh with Nike, okay? And to guarantee that those articles come up to a certain standard of quality, okay? And that's why these big businesses, those trademark owners would really go after counterfeits, right? And to advertise, of course, the articles that they symbolize. So when we see, let's say, that particular trademark, nasa isip natin, I'm going to buy that because it is a good brand, because I have had that before and I have liked it and it has lasted a long time. Okay. Now, you have to register again with the Intellectual Property Office in order for you to have rights over your mark, and the filing date of the application is the operative act to acquire the so-called trademark rights. So, class, prior use is no longer a condition precedent. Dati, yes, pero ngayon, hindi na. Okay. Before, when we say prior use, you have to be able to show that it was being used before, and that's why you have a right to register it. But now, even if you cannot show that it is being used before, then you can still have it registered. Okay? Now, gaano katagal? For 10 years, subject to indefinite renewals of 10 years each. So, you can renew it every 10 years or so. Now, halos lahat, pwede mo naman, diba, na i-trademark, okay, or to have these marks registered. But, there are certain things which you cannot do. Okay? So, marks which are immoral, deceptive, or scandalous, or disparages or falsely suggests a connection with persons living or dead, institutions, beliefs, or national symbols, or brings them into contempt or disrepute. That is the first one. You cannot have it registered. Then, the Philippine or foreign flag or coat of arms or other insignia or any of its political subdivisions or any simulation thereof, that is not allowed to be registered. Then, the name, portrait, or signature identifying a particular living individual, except by his written consent. So, you cannot use someone else's photo as your mark. Or the name, signature, or portrait of a deceased president of the Philippines during the life of his widow, if any, except by written consent of the widow. So, again, it only shows respect to our former or past chief executives. Also, no, a mark which is identical with the registered mark or a mark with an earlier filing or priority date, non-registrable. Okay. Now, here, ito na yung medyo exciting portion. Those which are identical with or confusingly similar to a mark which is well known internationally, again, sabi ko nga, parang kanina, Nike, so you cannot register it anymore. Okay? Whether or not it is registered here, doesn't matter if it is only registered in the US. Okay? Pwede ka nilang habulin if you have it registered here. Okay? And provided that in determining whether a mark is well known, account shall be taken of the knowledge of the relevant sector of the public. Now, it is a testament to how popular, no, or how good a product is if by the mark alone, alam mo na, di ba? May goodwill siya, gusto mo siya, alam mo na ano ang sinisignify nun. And we have a lot of products, okay? So, usually the logos of certain brand name goods, you know it. And it already carries, no, its reputation simply by its logo or its service mark or its trademark or even its trade name. Another thing which cannot be registered or another mark which cannot be registered is those which are identical with or confusingly similar to a mark considered well known which is registered in the Philippines. So yung kanina, whether or not registered in the Philippines, but this time those which are registered in the Philippines. Okay? Especially if likely, if there are instances wherein the interest of the owner of that registered mark will be damaged by such use. And usually, this is due to counterfeiting. Ginagamit mo yung logo nila or similar to that, and in order to counterfeit such items. Okay? Then, another mark which may not be registered is if it is likely to mislead the public, particularly as to the nature, quality, characteristics, or geographical origin of the goods or services. Inilagay mo doon, is it parang pinalalabas mo that it is made in USA when in fact it is made locally. Then, generic signs cannot be registered. Customary signs or those used in everyday language. So let's say yung mga traffic signs natin, that is not patentable and that cannot be registered anymore. Okay? Characteristics of goods like kind, quality, quantity, intended purpose, value, geographical origin, time or production of the goods or rendering of the services, that is also non-registrable. Shapes, no? So whether circle, triangle, rectangle can no longer be registered. Yun na yun eh. Colors by itself, so it is not cannot be registered, and anything which is contrary to public order or morality. So that take note. The trick class, in let's say for taking exams involving IP or intellectual property, is focus on what may not be registered. Okay? Basta pumasok siya doon, then definitely the filer cannot be allowed to register it. Kasi mas specific yung what cannot be registered as a mark or what cannot be patented, rather than kung ano yung universe ng alin yung pwede mong gawin. So parang generally you can, as long as not this list. So, tandaan ninyo, laging focus dun sa list of what may not be patented or what may not be registered. Now, when your mark has been registered, what rights do you have? So, first is to use the mark for one's own goods or services. So, dun lang, pwede mo siyang ilagay sa product mo, and you have the exclusive right to do that. And also to prevent other parties from using, without your consent, signs or packaging or containers which are identical to or similar to the registered mark, which may lead to confusion by the public. So, dalawa yung rights mo. Meron ka exclusive right to use, and second, to stop others from using it or anything similar to it. And that is the beauty of having your mark registered. Now, here, kung kanina sa patent infringement, if you use it without any authorization from the patent holder, here, mark infringement arises when any person, without the consent, again, without any authority from the owner of the mark, use it in commerce, sell, offer for sale, distribute or advertise any reproduction or to counterfeit or copy or colorable imitation of a registered mark or the same container or a dominant feature thereof. Now, this is important, so it does not have to be the same. As long as it is similar, as long as even just a dominant feature of that mark is used by another without your consent as the holder of the mark, then that constitutes infringement already. Okay. Now, to reproduce, counterfeit, copy, or colorably imitate a registered mark, and apply it to labels, etc. So, these things constitute infringement. And take note that, even if there is no actual sale of goods or services, there may already be infringement. So, it doesn't matter whether binibenta mo na o hindi. Pag ginaya mo, then that's it. Okay? Now, what is important when we talk about trademark infringement? The likelihood of confusion. That is most important. Okay? Remember, we can only have what? Iterations of, let's say, an image or a mark. Pero, if there is the likelihood of confusion, that is what is important. And if the answer is yes, then there is trademark infringement. That's what we look for, the likelihood of confusion. Now, when we say confusion, there are two things to be considered. Confusion of goods on one hand and confusion of business. When we say confusion of goods, no, let's say yung isa, original Nikes, and then we have the counterfeit Nikes. So, kung hindi ka maalam sa pagtingin what is an original or not, then you might be confused that, uy, it carries the Nike swoosh and therefore, bibili ako. Hindi mo na naisip na bakit tig-500 lang itong sapatos na to instead of the usual price of Nike products. Diba? Now, second is confusion of business. Now, here, even if that is not the same thing, okay? Kasi doon sa una natin, confusion of goods, because they're both, we're talking about shoes. Now, both of them are shoes. Isa lang nga lang counterfeit, yung isa original. But here, in confusion of business, even if the goods of the parties are different, the infringer's product is something which might be assumed to originate with the plaintiff. So, ayaw mo na ma-associate doon. So, kung sample natin, let's say, kunwari yung Century Tuna. Okay? So, si Century Tuna only carries tuna products. Okay? Iba't ibang version in oil, in what? In brine, etc. But essentially, I think they just carry tuna products and can this for sale. However, let's say another one says that ang nakalagay is Century din ang pangalan, and then similar yung packaging, pero ang nakalagay naman is let's say not tuna products but pork and beans. Okay, so this time, while the pork and beans are different from the tuna products which is associated with Century Tuna, then there might be confusion of business. So, uy, bibilin ko to kasi maganda ang quality ng Century Tuna products. So, bibilin ko ito kasi baka sa kanila din. Baka sila din ang manufacturer. Iyon yung bawal doon. Okay. So, what do we use in order to test yung, sabi nga natin, the gravamen of the offense of trademark infringement is the likelihood of confusion. So, what do we use? It is the test of dominancy. So, we look at the so-called dominant feature. So, it is what? You look for the similarity in the main or the prevalent or essential features of the competing trademarks. Okay. So, kahit na medyo ibahin yan ng infringer, ibahin ang kulay, if you can still be confused because of the use of let's say the dominant feature of that of the trademark holder, diba? Yung swoosh na yon, kahit na ang karaniwang swoosh ng Nike is white, tapos ginawa mo yung red, tapos ilagyan mo ng curly cues sa dulo, still the public might be confused that it is a Nike product, and then that's it. Okay, you are now using the test of dominancy. Basta, at the end of the day, the question is whether the use of the mark is likely to cause confusion or to deceive the public or the prospective buyers or purchasers. Now, what else? Baba ang pwede natin tanungin pagdating dito. So, unfair competition. Now, another concept which is used in IP is the so-called unfair competition. So, what is this? It means that the passing off or attempting to pass off upon the public of the goods or business of one person as the goods or business of another with the end in view of deceiving the public. Okay, so first, there must be a confusing similarity in the general appearance of the goods, and second is to deceive the public and defraud a competitor. Okay, so the test class here is whether the acts of the one who is said to be guilty of unfair competition, no, if what he's doing is calculated to deceive the public. Okay, so there must be proof of fraud. Okay, the intent to deceive or things like that. So karaniwan, counterfeiters, merong unfair competition agad doon, diba? Kasi you are trying to pass off what? Yung mga class A dun sa Green Hills na Louis Vuitton or Coach bags or whatever branded products. So even if of course the public know that they are simply class A, still the idea is it leads to unfair competition. Talagang hindi bibili noong original products because you have these imitations. So there is the intent to deceive, and there is of course fraudulent intent. Now, what else? Now, let's go to copyright. Okay? Now, this time, it is the right to literary and artistic works which are original intellectual creations in the literary and artistic domain which are protected from the moment of their creation. So, kung yung una, yung mga patents relate to inventions, diba, which should be new, which should involve an inventive step, something like that, may industrial application, and then we have marks which are images, names, etc., which distinguishes one product from the other. Here we have intellectual creations. So ano to? Songs, art, writing, etc. So how long? If ever you get a copyright on something which you wrote, it should last during the lifetime of the author and even 50 years after his death. Okay, and so what are these? There is a very long enumeration of the works which are covered by our copyright law. Okay, so first we have the so-called literary and artistic works on one hand, and then we have the derivative works. Now, so literary and artistic works, we have books, pamphlets, we have periodicals, lectures, dramatic composition, letters, photographic works, drawings, illustrations, audiovisual works, computer programs, and other literary, scholarly, scientific, and artistic works. So let's say you wrote a book that is covered by that. You had a lecture, then yes, that is covered by that. It is protected from the moment of your creation of that particular work. Now, second, we have the derivative works. Okay, so still, even if they are derivative works, they are protected as new works. Okay, and it will not affect the force of any subsisting copyright upon the original works. So let's say best example of this would be translations. Translations, adaptations, and other alterations of literary or artistic works. So, may original, pero merong kang different iteration of the original. That is a derivative work. And then, we also have the collections of literary, scholarly, or artistic works and compilations of data and other materials which are original by reason of the selection of coordination or arrangement of their contents. So, let's say you decided to have a book, compilation of poems by contemporary poets, something like that, and then you chose it. You're the one who compiled it. You chose certain poets, and not just certain poets, but let's say female poets of the 21st century. That's your idea, and so you collected the poems of Maya Angelou and other female poets, and that's it. And your book was published. That is a derivative work. it is considered as new. Okay, so it will not affect the right, no, of Maya Angelou and the other poets to their own work. What you have is a right not over their works, but a right over your compilation of the published work. That's it. Okay. So, like in trademarks and like in patents, there are also matters or things or ideas that cannot be copyrighted or are non-copyrightable. So, any idea, procedure, system, method, or operation which principle, discovery, so yun, yung parang medyo wala na siya, hindi siya yung gaya doon sa covered na noong literary and artistic works. So, news of the day is non-copyrightable. Okay? Official text of a legislative, administrative, or legal nature, and official translation on. So, yung nasa official gazette is non-copyrightable. Any work of the government of the Philippines except if it shall be used for profit. And then our laws, no, rules and regulations, it's not copyrightable. Speeches, lectures, sermons, no, if they were pronounced already, let's say in the court, kapag sinabi yung order, no, these are non-copyrightable because it's part of their adjudication. So these are non-copyrightable. So in case of original literary and artistic works, the copyright shall belong to the author of the work. So if I write a book, the copyright belongs to me. Now, if joint authors, then the co-authors. Okay, so pwede yun, diba? And if you are employed, no, and that's when you wrote this particular sermon or lecture, etc., then it is the employee if it is not part of his regular functions. Now, it is the employer if it is the result of the performance of the employee's regularly assigned duties. So, kunwari, I do not have copyright over the memoranda which I do for the office or for the rules which I draft and are later on signed by the ombudsman. So, because it is part of my functions as an assistant ombudsman. It is only when it is not part of my regular duties that it becomes my copyright or that I can have a copyright over that. Okay? So, if it is a commissioned work, then ownership shall belong to the person who commissioned the work. Okay? But the copyright, no, shall remain with the creator unless there is a written stipulation to the contrary. Pag audiovisual work, to the producer, no, the author of the scenario, the composer of the music. In case of letters, to the person to whom they are addressed and delivered, not to the writer. Okay? But before the letter can be disseminated, then there must be consent of the writer, kasi private yun, di ba? Or his ears. So, for instance, si Gat Jose Rizal sumulat kay Josephine Bracken, nagligawan sila, di ba? Yung mga huling letters niya. The copyright belongs to Josephine Bracken. But prior to having it published later on, then Josephine Bracken should ask the ears of Gat Jose Rizal. So that is just an example. Okay? Now, let's say anonymous or pseudonymous works, then the publishers who represent them shall be considered as owning the copyright. So, kunwari, diba, let's say Stephen King, he usually writes, no, not just in his own name, Stephen King, but using other pseudonyms, then, of course, his publisher knows that it is him. Diba? Kaya sa kanya pa rin yung royalties in the book, etc. But, kasi disclosed naman siya, at least as far as his publisher is concerned. So, yes, no, it now belongs to him. But if he is really not known, then it belongs to the publisher. Now, what else? So, if you own a copyright to anything, what do you have? We have the so-called economic rights. Okay? So, again, the exclusive right to carry out, authorize, or prevent the following acts. Carry out, authorize, or prevent. So, you can reproduce it, or you can authorize the reproduction or stop the reproduction. Then the dramatization, translation, adaptation, or abridgment, yes, you can do that or not do that, or not allow to do that. Then first public distribution of the original and each copy of the work by sale or other forms of transfer or ownership, that also belongs to you. The rental of the original or a copy of an audiovisual or cinematographic work, work embodied in the sound recording, a computer program, compilation of data, etc. Yes. Then the public display of the original or a copy of the work, public performance of the work, and other communication to the public of the work. So that comprises your economic rights. So either you cause it, meaning ikaw magpaproduce o ikaw ang mag-stage, or you authorize someone else, or you stop someone else from doing it. Okay? Those are your exclusive economic rights as the copyright holder. Okay? Now, second, group of rights would be the so-called moral rights. Okay? So you can require attribution to you. Akin yan, di ba? Huwag mo sabihin sa'yo. Okay? Now, to make alterations of your work or to withhold it from publication. Ayaw mo, di ba? Huwag nyo i-publish yan. Or to object to any distortion, mutilation, or other modification or other derogatory action in relation to his work. So let's say you own the copyright to a certain piece of art, a painting, and then someone else, decided to make a copy of it and actually bastardized it. So you can stop him. It is now within your moral rights. You're stopping him not based on the exercise of your economic rights. You're stopping him because you don't want him to distort your painting or your idea behind that painting. And to restrain the use of your name with respect to any work not of his own creation or in a distorted version of his work. So ayaw mong makonect doon yung pangalan mo. Hindi yun sa'yo, okay? You do not have, let's say, that is a different work altogether. However, you will be affected by it in a negative way. Then you have the moral right to stop your name being associated with it or used with it. And that is what differentiates, let's say, copyright infringement or copyright rights from that of trademarks as well as patents. Because here, we have what is known as moral rights. Doon sa iba, more on economic rights. You can stop people from profiting of your service marks or your trademarks, etc., or confusing the public and thinking that they are your work. But here, aside from the economic rights for the use and reproduction and etc. of your work, here you also have moral rights which extend far beyond your rights to as the copyright holder. So can you waive your moral rights? Yes. Okay. And when we talk about infringement in copyright, it is more of piracy. Okay? So copyright infringement is really more on piracy. So here, just because you copied, sa piracy, let's say mga movies or what, copying is not what is prohibited. Okay? There must be what? There must be an injurious effect. Okay? Lalo na kung pinagkakakitaan o kaya lumabo yung quality, kaya ayun, bumangit, kaya naapektuhan ngayon yung sales of the original work. Okay? So, iyon yung mga bawal doon sa copyright infringement and piracy. So, it is a mixture of economic and moral rights. Economic kasi sa halip na ikaw ang kumita from the showing of that film or from the reproduction of that film, someone else is profiting of you. Now, on the other hand, yung ding moral rights mo kasi nabababoy, di ba? Kasi pangit yung quality, let's say, because they reproduce it, low quality, etc. And your reputation as a filmmaker may be affected by when people see this particular version o kaya kinat-cut nila, etc. So, similar things like that. That is the idea. Okay. Now, so, parang din tayo makakilos, di ba? Kasi parang lahat na lang kailangan mong ask the authority or the consent of the copyright holder in the case of copyrights. But we have what is known as the fair use doctrine. Okay, so it contemplates that the fair use of a copyrighted work, no, for criticism, comment, news reporting, teaching, no, including making copies for classroom use. So lusot kami dyan, di ba? Scholarship, research, and similar purposes. This does not constitute copyright infringement. Okay? Kasi otherwise, again, ano yung kailangan ko magbayad or kailangan ko manghingi every time I need to talk about, let's say, what is written in a book. Diba? Or if I wanted to, let's say, quote an opinion stated in the book of, let's say, Attorney Cesar Villanueva for Philippine Corporate Law. So, hindi ko masasabi if I do not ask for his consent. So, under the doctrine of fair use, I should be able to do that because what I'm doing is part of my teaching, part of scholarship for academic purposes only. Now, for criticism, or let's say, diba, it's part of your, you know, in your article in a newspaper. So, you need to put in there the photo of the work which you are analyzing, no, as part of your critique. So that's it. Just take note, no, when we say doctrine of fair use, no, usually there's no commercial purpose attached to it, kaya nagiging part ng or pasok sa doctrine of fair use. But if you're already profiting from it, then it might no longer be covered under the doctrine of fair use. You also have to consider the nature of the copyrighted work and the amount and substantiality of the portion used in relation to the copyrighted work. Baka naman kinopy mo ng buo, di ba? Baka yung buong libro, and we are guilty of that when I was still a student in law school. We were actually photocopying the entire book because we did not have the money to buy the originals. So yes, we were guilty before. But well, hindi naman yon pinakopya, no, pinasirox at saka ibinenta. Iyon naman ay ginamit namin para sa sarili. But of course, class, hindi namin pinapakita yun sa aming mga professors back in the day. Why? Because if we do that, gagalit sila sa amin. Oy, bayad kayo, bumili kayo because you are you are mulching off, sabi niya, parang something like that, dun sa dapat kinikita ng authors. Pero syempre, wala kaming pambayad kaya sige, photocopy pa more. Okay? Now, and again, the effect of the use upon the potential market for or value of the copyrighted work. If it will now prejudice the copyrighted work, then even if initially you think that it will fall under the doctrine of fair use, then baka hindi at baka meron ka ng infringement. Okay? So, please take note of the limitations on copyright as provided for under Section 184 of the Intellectual Property Code. Medyo mahaba yun, di ba? Pero suffice it to say that it talks about what will not constitute infringement of copyright. So parang pasok pa din doon sa discussion natin on fair use. Okay? Again, rule of thumb, class, if there's no fraud involved, if there is no commercial purpose intended, it will not prejudice the reputation of the holder of the copyright or of the nature of the work itself, then most probably there is no infringement. Okay? Di naman ganon kahigpit dyan. Kasi it's like a free market of ideas, and without that, no, hindi mo nang pwede solohin yung work mo. Okay? And even authors, writers, etc., wala silang magagawa doon kasi they also have to publicize it. Okay? And sometimes, it being played in public or it being quoted, let's say in classrooms, it actually ups the value of that work, and it actually makes you more well known. So you have also to consider that. So, what would be your remedies in case that there's copyright infringement? Then you need to, you may file an injunction so that you can restrain the infringement. Sabi ko nga, it's one of your economic rights. And then, you can also file an action for damages and loss of profit if ever it was your economic rights which was violated. And then, you can also have the offending materials, the materials to be seized, impounded, and destroyed, no? And you can also file a criminal case against the infringer. And usually, this is in relation to pirated, diba, films, etc. and counterfeited goods. Goods, books, etc. Yun, yung mga gano'n. So, kaya pwede mong pasunog, diba? Yung mga madaming mga, usually makikita natin, sinusunog yung mga pirated DVDs galing Quiapo. Pag nag-raid doon yung MTRCB or some other government agency, ayun. So, that can be done. And who does this? The copyright owner. Usually, the producers of the film, etc. Kasi, as in case of pirated films, hindi pa napapalabas, diba? O unang showing pa lang sa theaters, tapos meron ng kopya. And therefore, yun na lang ang bibilin mo, hindi ka na manonood. So, it actually affects the profit of that can be made from that film. And that's why it is really prohibited, and they actually really come after these video pirates. Okay? So, that is one good example of infringement of copyright, and that would be your remedies in case it happens. Okay, so that ends my discussion of IP. I hope that this does not affect the report, no, of I think Jaira and Albert, no, Mr. Ramos. They are still going to continue with the report when I come back, but at least you can use this as a reference, because again, when we talk about this, just remember, okay, remember to distinguish patent from trademark from copyrights, and then what is the nature of these three, what are being protected under these three, what are the rights, no, which you can exercise as the holder of a patent, of a trademark, or a copyright, and then finally, what are your remedies as a holder of such right. So if you can put that in a matrix, then you're good to go. Okay, so thank you for listening, and good day.